I'm always happy to be here at St. Leonard's, being an actual neighbor in the neighborhood next door. So it does bring me pleasure to come and talk to you guys about estate planning. And shining moment for mom of four. My oldest is a freshman at Alter, and he successfully, as a freshman, made varsity cross country this year. And we're going to his banquet tonight. So yeah, I'm pretty excited for him. So don't tell the other three I didn't brag on them, okay? So we're going to talk a little bit about estate planning today. I would love for you guys to ask questions. Please ask questions throughout the presentation. I would ask that if you have a specific question about you or a loved one, please just ask me after. But if it's a general question, I'm happy to answer those as we go, okay? What is estate planning? Many people think of estate planning about that moment in time when we die, right? Most people just think estate planning is about where does my stuff go. But the reality is it's really about taking care of your legacy and also about planning for disability. Most of us don't think about that disability part, okay? And the reality is 80% of us will have a period of temporary or permanent disability in our lifetime. And so when we talk about estate planning, it's more than just a legacy, okay? It's also about making sure that we have someone in charge to take care of us, our person, our healthcare decisions, and our business, okay, our personal business, if we can't, right? Because if we don't make those decisions while we have the ability to, guess who gets to make those for us? The government, yep, whether we like it or not, okay? These are the typical common death plans that we see when we do estate planning. About 80%, it's kind of a typical statistic here in estate planning, but about 80% of us do no significant estate planning in our lifetime. And so what that does is it leaves our legacy, our decisions, up to the government, whether we elected them or not, okay? So when we don't do anything, okay, we've made no decisions for ourselves. Another one typically is we own everything jointly with our spouse. There's definitely a reason to do that, and we see it commonly with real estate and things of that nature. And we're going to talk a little bit more about these 5 different death plans. Owning everything jointly with your child. Problem there, if I leave everything jointly to my child, what if I have more than one, right? If I leave everything, if I decide that my estate plan is going to be leaving everything to myself and my oldest, right? So we both own all of my stuff jointly. And then I die, guess who gets all my stuff? My oldest son. And it's up to him to decide whether or not he wants to share with his siblings, okay? I hear this all the time. Oh, my kids get along wonderful. It's not going to be an issue. He'll share. It's fine. Guess what? Money does weird things to people, right? And so you're not guaranteed that they will do what you want them to do unless you have it in your estate plan. Similar with owning everything jointly with your spouse. While that's a great plan, when the first of you dies, guess what you've done? You've now put that burden on your spouse. So that spouse who's grieving you now has to make all the decisions alone, hoping that they knew what you wanted, especially if we're in a blended family, right? Did my husband want his son, who he hasn't spoken to in 25 years, to get any of our stuff, right? So when we don't have those discussions and make a thought-out plan together, we leave things out there, that decisions that your wishes may not be accomplished, okay? Giving things away during my lifetime, great. We all know that there's the tax exemption, right? I can give $18,000 to every single person on this planet, and the IRS doesn't care, right? I can give my house to my kids, right? I can do all of those things while I'm alive. However, what don't you own when you give something away? The thing, right? So we had an example several years ago where this woman came in to see us, and about 7 or 8 years ago, she had given her house to her daughter. This was her attempt in protecting the house from a potential long-term care event in Medicaid, okay? Daughter, perfectly good, responsible adult, okay? Only child, so we didn't have to worry about her not sharing, okay? But guess what? Daughter got in a car accident. Daughter was uninsured. Daughter had to file bankruptcy. So mom got a note from the bankruptcy trustee that said, hey, you've got two options. You can buy this house for me, or you have 30 days to get out. And so mom came to us and said, what do I do? And we said, unfortunately, you have two options. You can buy the house for the second time, or you can get out. So mom had to buy the house for the second time, okay? So while we have good intentions in doing those kinds of things, when we give stuff away, we open ourselves up to that person's liabilities, okay? Additionally, there's tax consequences with that. Using the house again as an example, I give my house to my son while I'm alive, okay? I paid $100,000 for my house. When I die and my son decides to sell my house, it's worth $500,000, okay? Because I gave my house to my son while I was alive, he now has to pay capital gains on the difference between what I paid for it and what he sold it for, at 20%, okay? If I had waited and the house just went to him when I died because he was my next of kin or he was my beneficiary in my will, no capital gains. We have a step up in basis to the value of the house when I died, okay? So there can be unknown or unforeseen tax circumstances when we give things away during our lifetime. Most importantly, though, when we're talking about disability planning and long-term care, is that if I give things away during my lifetime and I end up needing Medicaid, okay, I will be penalized because I'm not allowed to give away my assets within 5 years of applying for Medicaid, okay? So while the IRS doesn't care if you give $18,000 away to all your grandkids every year, Medicaid's going to care. And typically when we give something away, we're not getting it back, right? We're not getting it back. So while giving, I always tell people, if you want to pay for your grandkid to go to college, or you want to buy that new car for your child, or whatever it is you want to do because it makes you feel good while you're alive, go ahead and do it. But just remember there's potential consequences with that, right? Lastly, another typical one we do is what's called a TOD, a POD, or a beneficiary designation. So a TOD is a transfer on death. That's typically put on property, so vehicles, homes, titled or deeded assets, okay? Transfer on death. Payable on death, POD, is typically on money assets, right? Bank accounts, CDs, those types of things, payable on death, okay? And then beneficiaries are typically on things like life insurance, retirement accounts, 401ks, IRAs, Roths, okay? What happens with a POD, TOD, or a beneficiary is we aren't giving any vested right in that asset while we're alive, okay? What happens is when we die, the asset automatically transfers to them without probate, okay? The downside in those is that what happens if one of your beneficiaries, POD or TOD designations, what if they die before you? What happens then? Well, we may have avoided probate for ourselves, but we've created probate for them, okay? Also, what happens if one of those beneficiaries becomes disabled or is already disabled, right? Adult disabled child, or becomes disabled down the road and is receiving government benefits. Well, now unintentionally, by allowing them to just inherit from those, we've potentially made them lose their benefits, okay? So we have to be really thoughtful in how we go about making these types of decisions. 6 basic estate planning documents. These are the 6 basic documents that anyone 18 or over should have, okay? This isn't limited to people that are retired. This isn't limited to people who have a terminal illness. This is for anybody 18 or over. So number 1, financial power of attorney, sometimes referred to as a general durable power of attorney. This is the one where you appoint someone to make financial decisions for you, okay? This is the person that you appoint to renew your Medicare if you're unable to do that. This is the person who's going to pay your bills if you can't, okay? They're going to do all of those things that you do on a regular daily basis as your own little business, right? You can have multiple power of attorneys. You can have 2, for example, and those 2 individuals can either have to act in unison, meaning 2 signatures are required, or they can act unilaterally. They can be joint, but only 1 signature is required, okay? We also do the succession. That's the more typical way, but sometimes we do joint. Succession meaning, oldest to youngest child, or spouse and then kids, right? Healthcare power of attorney, this one is part of the 2 documents in Ohio that make up what we call our advanced directives. So it's our healthcare power of attorney and our living will. Healthcare power of attorney is that other half of the decisions we make for ourselves, right? So the healthcare power of attorney, we appoint someone, and this can only be 1 person, we appoint someone to make those healthcare decisions for us. And you can have a succession on that as well, okay? Living will, like I said, that makes up the second part of our advanced directives here in Ohio. Living will is a document you can choose to sign or not sign, okay? In the living will, what you're doing is you're making decisions while you have the ability concerning end-of-life treatment, okay? So if you execute a living will, you're telling your loved ones and your healthcare power of attorney that if 2 doctors are in agreement, okay, that you're either permanently unconscious, okay, so you're never waking up, heart can't beat on its own, can't breathe on your own, can't eat on your own, all right? Or you're terminally ill, and that terminal illness is eminently going to lead to your death, okay? i.e. we have cancer and there's no more treatment available, right? If one of those 2 situations arise and you've executed a living will, what happens is they will not resuscitate you and they're not going to put you on life support, okay? Now, if COVID was a good example of this, if you go to the hospital, okay, and a respirator or intubation or something like that is required to make you better, you can still say, yes, I want that treatment, okay, even if you've signed a living will, because you're not permanently unconscious, right? So you can still say yes to those treatments, and nobody can remove those from you unless and until it's determined that they're no longer making you better, right? Okay? If you don't sign a living will, your healthcare power of attorney is going to be the one to make those decisions for you, all right? And lastly, I like to point out about the living will, it does have a do not resuscitate in it, limited to those 2 circumstances, right? Permanently unconscious, terminally ill, and imminently going to lead to your death, okay? They will not resuscitate you. But if you want a blanket do not resuscitate, that has to come from a doctor, okay? Lawyers can't do that for you. HIPAA, we all know what that one is. That's giving access, right? Not decision-making power. That's what the healthcare power of attorney does. So you have your, my son is my healthcare power of attorney, but I have all of the kids listed on my HIPAA, so assuming they were 18, so that they can call and ask how mom's doing if she was in the hospital, okay? Disposition of remains, interesting one. In Ohio, so the only person who has the authority to make decisions about our remains when we die is our spouse, okay? So if we are widowed or unmarried, okay, at that point, they're going to look to your children. If you have multiple children, like me, for example, they all have to be in agreement. So I always use the example, right? My kids, Matt goes to Altar and the other 3 go to Incarnation, raised Catholic. If I tell one of my kids I want to be cremated, and my youngest daughter says, absolutely not, mom wants to be in Calvary next to grandma, right? I sit on ice until the 4 of them can agree, okay? So again, goes back to, hey, listen, my kids, oh, it's fine. They're all going to do what I say I want. It's no big deal. We've all talked. Stranger things have happened. The question was, do you put that in your trust, how you want your remains? And it's actually in the disposition of remains. So it's a separate document where you actually appoint someone to make those decisions for you. Again, it can be in succession, just like our financial and our health care. And then there's places where you can say, I want to be cremated, or I want you to use this life insurance policy to pay for my burial. And of course, and I'm sure you guys have all listened to people talk about pre-planning your funeral. So that's always an option as well, right? You can go in and actually take care of that in advance so that those decisions are made, okay? Last one, revocable, irrevocable trusts. And we're going to talk a little bit more, and last will and testament, we'll talk a little bit more about that in a little bit. So the question is, do we have to go to the doctor in advance and have the doctor do the living will? No. So living will is something that can be done by an estate planning attorney. Also, sometimes people may go to the hospital for surgery and they're going to ask, hey, do you have a living will? And if you say, no, I don't, they may explain it to you, and then they can do it for you there also prior to the procedure. They are revocable, all of those documents that we talked about. All of those documents are all revocable at any time. They can always be changed. So if after you come out of surgery and everything's fine and you say, I don't think I want that anymore, revoke it. Yeah, so the question is, just to clarify about the DNR, that does have to be done by a doctor. Typically, most of the time, doctors aren't going to put that in your chart unless there's a reason, right? You know, dementia, ALS, something that's progressed. Because most of the time, if we're healthy, we want to be brought back. It would be a good idea. I know some people who have things like ALS or Parkinson's or whatever, and they have a DNR, and they've got a sticker on their front door.
On my fridge.
Yeah, on the fridge. Everybody knows about it. There's bracelets you can wear. Typically, when people are in a skilled nursing facility or in the hospital, it's going to be above their bed. Okay, or on the door when you walk in. So, because the interesting thing when you think about treatment in a DNR is, if something happens, you have a heart attack and at home, and somebody calls the EMT, their job is to bring you back, right? They're going to bring you back. But if you're 103 and 110 pounds, and you're like, I don't want them breaking my ribs, I've lived a good life, and if I have a heart attack, I'll see you on the other side. Then, number one, we don't want people calling the EMT, but number two, you need to have that documentation present and available.
Do not resuscitate.
Correct. DNR means do not resuscitate, that's right. So the HIPAA is privacy. So many, many, many years ago, Congress decided that we aren't just going to be allowed to get anybody's healthcare information, right? And so now every time you go to the doctor for your physical annually, you know how they give you that form that says, who can we release this information to? Or can we leave messages about your treatment on your voicemail? All of those types of things. That's because of HIPAA, okay? Do not resuscitate, completely different. HIPAA just allows them to release information to those people, okay? Do not resuscitate or the living will. You're making decisions now while you can about that end of life treatment. The question is a do not resuscitate, should it be number 7? Or is it part of this? So remember, this is just the basic estate planning documents that anybody age 18 or older should have. A do not resuscitate, I'm not going to have a do not resuscitate. If I dropped a heart attack right now, I'd want you guys to try to bring me back, right? But if, I'm 95 and I have cancer, well, maybe I don't want to be brought back, right? So it's not an essential document. It's really a decision based on the person, right? Between the person and their doctor. Powers of attorney. Healthcare and financial power of attorney. Anyone over the age of 18 can and should execute it. If you have grandkids or kids in college, it should be the first thing that they do before they leave, because if they do something dumb and they end up in the hospital, guess what? Mom and dad can't access their bank account, and technically mom and dad shouldn't be getting information and shouldn't be making decisions, okay? So we want to make sure everybody has those documents in place. We also want them to be durable. In the state of Ohio, they're presumed durable unless stated otherwise. That just means that they're going to continue during a period of incapacity or disability, okay? So they're good all the time, okay? Part of the power of attorney, the authority that you delegate to your agent, okay, dies with you. So people get this confused a lot. They always say, well, I have a power of attorney, or they're my executor. The authority that you delegate in that power of attorney dies with you, okay? The executor is in your will, last will and testament, and they only get authority if we go to probate. So if we don't have our power of attorney because we're dead, and then we just have this executor over here, there's a period of time where nobody has access to our stuff, okay? Unless we have beneficiary designations or unless we have a trust, which we'll talk about, okay? Does that answer your question? Financial power of attorney. Again, we talked about this. I do want to point out that I get a lot of calls as an elder law attorney from families who say that the facility or the hospital has told them they need guardianship. This comes up a lot when someone has a dementia diagnosis, something along Parkinson's, those types of things. I want you to always remember that medical capacity, okay? So a doctor telling you or your loved one that someone doesn't have capacity is completely different than someone having the capacity to sign a power of attorney. Guardianship, and we'll talk about this a little bit later, it should be last resort. When we get a guardianship, we're taking away that person's right to make any decisions at all, okay? So if we can get a power of attorney signed, all right, that's our best path, okay? So it's important to remember that. Also, important to remember, a couple years ago, the Ohio legislature passed a law that says we can now have a designated signer. So came into play for me for the first time when there was a gentleman, he was in his late 40s, had an accident at work, became a quadriplegic. So couldn't use his hands. But quite frankly, he couldn't really talk very well, but he could blink and things like that. So they didn't have any documents in place. So wife called me in, I brought my paralegal, okay, and we asked him, hey, Bob, is it okay if Annie signs these documents for you? We went through them, made sure he understood he was in agreement, and then she signed as though she was him, okay? So I know it doesn't come into play a lot, but important to remember just for you and your own knowledge and educating out there in the community. We talked a little bit about this already, part of the Ohio Advanced Directives. It is important for you to understand that when you are appointing that individual to be your power of attorney, they are supposed to be standing in your shoes, okay? They're supposed to be making decisions as though they were you, okay? So if, and this comes into play a lot when we have maybe conflicting religious beliefs, right? But, you know, if I'm an atheist and I think that, you know, there is no heaven and who cares, you know, let's all be cremated and just blow them in the wind. But my mom, you know, is a staunch Catholic and believes that there's going to be a time when our bodies are going to get raised from the ground and that has to be required for us to go to heaven. I don't get to say that's a stupid belief. And I'm going to cremate you anyway, okay? So we're supposed to be making those decisions as though they were making those decisions when we act as an agent, okay? But when you're picking your agent, probably important to make sure, if you have the option, that number one, they know what you want, and number two, that they kind of have the same philosophy as you as well, okay? Living will, again, talked about that. 2 doctors have to be in agreement. And it does include that limited do not resuscitate. So the question is, please clarify the last point. So yes, there are limits on the authority of the healthcare power of attorney. So when I talked previously about COVID, and if you went into the hospital and they decided that respirator or doing some feeding tube or you've agreed to a colostomy bag or whatever, the agent cannot remove that from you if you agreed to it. And then, of course, they can if you've agreed to some sort of life-saving treatment, and then it gets to the point where it's no longer helping, right? At that point, when 2 doctors agree, now that healthcare power of attorney can potentially remove that life-saving treatment. Permanently unconscious state, what does it mean? So again, 2 doctors have to agree to this, and it's really that there's no higher brain function and that person is unable to feel pain, okay? I'm not a doctor, so I don't know how they make that determination, but that's your definition there for that, okay? Terminal condition, again, irreversible, incurable. It has to have been caused by a disease or an illness, and again, 2 doctors have to agree within that reasonable degree of medical certainty. They do an examination, obviously, and then they're going to make this determination that there's no chance of recovery and that death is likely to occur in that short time without treatment. Okay, I promised, guardianships. So we just talked a lot about power of attorneys. What happens if we don't have a power of attorney and we come incapacitated? Guardianship, okay? Path of last resort. We don't want to do this, okay? It's expensive. We don't get to make decisions. Also, the court has to have full approval of all decisions, okay? If we have, just like a healthcare power of attorney and a financial power of attorney, we have a guardianship of our person, okay, that's for healthcare decisions, and a guardianship of our estate, that's for financial decisions. If we have a guardian of our estate, that individual annually has to provide a report to the court that they have to approve, agreeing to all the expenditures that they did on your behalf. Every year, into perpetuity until you die. So it's really not, it's not the best path if we can avoid it. Certainly sometimes we have to do it, right? But you guys are all here, you're all healthy, you all have capacity. So let's make sure we have our power of attorneys in place and then we don't have to do this. Okay, the big one, what's a will? People tend to tell me all the time, I have a living will. Okay, but do you have a last will and testament? Yes, I have a living will. Living will is a completely different document than your last will and testament. Living will, the one that we make decisions about end of life. Last will and testament, where does our stuff go? Okay? It's also, if you have minor children, where you would appoint a guardian of those kids. Okay? Wills have to go through probate. Also, it's important to remember, wills do not trump trusts, payable on death, transfer on death, or beneficiaries, okay? Beneficiary designations, okay? So I get that a lot too. Well, I'm leaving everything equally to my kids and my will. Fantastic. But my son's joint owner on all my bank accounts and my investment account, and you know, I left my IRA to my grandkids. Well, guess what? What that will says isn't going to happen, okay? So you have to remember when you're doing planning, okay, that it should be a holistic approach, okay? If you're talking to somebody that says, and you call them, you say, hey, I need a new will, and they're like, okay, great, yada, 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 come on in, sign it. And that's all they do, problem. Because they have no idea what assets you have, how you have them, where you have them going, who owns them with you, okay? And that's going to govern things before the will. So that's a really, really important thing to remember. Guarantees probate. Nobody likes probate, trust me, even attorneys who do it. It's a public record, okay? So if you've disinherited a child or you have somebody in there that nobody knew about or whatever it is, it will be on the public filing system for everybody to see. Additionally, probate is public, and we're required to create an inventory when we do probate. So if you've got $10 million and you've lived the most humble life and you never want anybody to know that, guess what? Everybody knows it, and now they know what your kids have, right? Yes, sir?
But if it goes to the spouse, it doesn't have to go to probate, right?
If the spouse owns the assets with you jointly or is a transfer on death, payable on death, or beneficiary. And with another caveat, if it's a vehicle. Yeah, so you can transfer up to, a surviving spouse can transfer up to 4 vehicles with a total value of not more than $60,000. But if you own your house in just your name and you're married, we're going to probate to give her the house.
But if it's in both names, it doesn't go to probate.
So long as it's joint with right of survivorship. Yes. Then it wouldn't go to probate until the last of you passes. Okay? Also, if we're in a blended family and we didn't have any biological children together, the spouse doesn't necessarily get everything. Okay? Your biological children, if they are adults, may get some of your spouse's inheritance. Okay? So not always. If you don't have a will and everything's in your name and you die and we have to go to probate and you're married and you had kids together or don't have any kids, either way, yes, everything by law will go to your spouse, but we still have to go through probate. So question is about amending a will and married-in potential married-in beneficiaries. So yes, you can amend your will, and you can do that anytime. We don't notarize wills. They have to be witnessed, okay? So in Ohio at least. And so any attorney could do that for you. As far as amending it, yes, you can amend it to add your daughter-in-law. But the question is, do you want to? And it's not a judgment of your daughter-in-law. We typically advise people to keep their lineage in the bloodline, okay? Because what happens is, let's say you do that, okay, and then they get divorced. Or God forbid, she dies and he gets remarried. Well, now you're amending your plan because of his situation, okay? So typically, we just keep everything kind of in the bloodline, and if they're still married, obviously, hopefully she'll reap from benefits from that inheritance, okay? Wills also, like I said, in order for them to enforce where your stuff goes, they have to be probated. They have to be deposited with probate court. Someone has to affirmatively go there, pay the money, and get it open, okay? Once that's open, your estate is now vulnerable to creditors, and it makes the contest by people you maybe disinherited or otherwise feel they have some right to your stuff to enter into that action, okay? Because they just have to file a form, doesn't cost them any money, and now they're contesting, okay? So, and then of course it does require a court proceeding, time consuming, and it can be expensive. Yes, sir? So the question is, how can someone contest a will if I've made decisions that it goes to A, B, and C, and D says, well, I think I should have been in that? Well, we live in the United States, and it's litigious society, and anybody can sue over anything, really. But to your point, if it's a child who feels like they should have a right, they can claim that you were under duress, that you didn't have capacity, that one of your kids was over there with a gun next to your head telling you, leave my brother out. Will they win? Probably not. The evidence isn't always easy to provide, but they still have the ability to do it. And now the legitimate heirs have incurred those attorney fees to try to fight, right? Sometimes people will put a contest clause in it that says if you contest, right? Because I left my youngest 10% and everybody else, gets more, and she decides, well, I don't think that's fair. I want the same amount as my siblings. I can put a a contest clause in there that if she then contests and loses, she gets nothing. So she doesn't even get her 10%. But it doesn't prevent them from that contest. So the question is, if you own your house jointly with your spouse and your spouse dies and then your kids are your beneficiaries, does that have to go through probate? Well, the typical attorney response is it depends. Number one, did you own the house joint with right of survivorship with your spouse? If so, then yes, we do what's called an affidavit of survivorship, that the surviving spouse attaches the death certificate, and we say, hey, this person died, here's the death certificate, I was their spouse. Now it's mine, okay? Now, when we say, does it go to my kids as beneficiaries, are they beneficiaries in the will, or did we add a transfer on death designation to the deed? Okay? If we add a transfer on death designation to the kids on the deed, that passes to the kids outside of probate. Okay? If they're in the will, wills have to go through probate to direct property. Or we can have our trust own our house.
That's different.
So when you use the word beneficiary, that's different than being a joint owner. So let me clarify. So the question, so two answers to that. If the children are on the deed as joint owners with a right of survivorship and you die, then your share goes to the kids through an affidavit of survivorship, okay? If they are transfer on death, you still own the house fully during your lifetime, okay? And then it goes to the kids at your passing. Does that make sense?
Yeah, but if you make a totally new deed.
That's what I'm, correct. So the deed would be the Q and Bobby Sue own the house 50-50 with a right of survivorship. It does not go through probate when you die, assuming Bobby Sue's alive.
One needs to make a new deed after your spouse dies.
Yes, for sure. Yep. At a very minimum, to get the house into your name. In fact, I have a probate going on right now where spouse died 11 years ago, and they never bothered to deal with the deed. And so now they're trying to sell the house, and we have to get, unfortunately, it was enjoying its right of survivorship, which is probably why they decided never to do anything about it. It'll be somebody else's problem, and now it's their kid's problem. And so now we're probating half of the house for the wife to get it transferred into husband's estate so that he has full ownership so that the executor can sell it.
But my wife passed, so I had the deed in my name now exchanged.
Correct.
But I want to do the next step.
Correct. And so that's what we've already talked about. You either do a transfer on death, you make them joint owners, which I don't believe is your best option because they're going to pay capital gains, or we put it in the trust. Yeah. All right. Good questions. So trust, 3 important roles: trust makers, trustees, beneficiaries, okay? Trust maker, trustee, and beneficiaries can all be the same people. What, Rachel? That sounds crazy. Well, it's true. So I'll give you an example. I have a revocable living trust, okay? I'm the trust maker. I created it. My stuff went in the bucket. I'm the trustee. I get to control all that stuff. And I'm the beneficiary while I'm alive, okay? So the benefit for me in that trust is that if I become disabled, okay, my brother's my trustee. He can continue to access my accounts to pay for my kids' tuition, sports fees, whatever, food, Sam's Club, every day, all of those things. And then when I pass, someday when I pass away, he would then also step in as that trustee and be able to distribute to the children if they are 25 or older, okay? So that's an example of how you can be all 3 things. Yes?
Is it wise to list a second trustee?
Always. A successor?
Right.
Yes, we always want. First of all, if you're doing a revocable trust, like the one I just described, I need a trustee identified for when I pass away, okay? But also, one of the advantages for a trust, which we'll hit on, is that it avoids living probate. What is living probate, Rachel? That's guardianships. That's I'm disabled. That's the bank who doesn't want to accept my power of attorney that I executed 10 years ago because it's too old. Or because I've been diagnosed with dementia and they don't want to accept it. But I did it 10 years ago when I didn't have dementia so that I would have it in place if something happened, right? If it's in a trust, banks can't do anything, can't reject a POA. We don't have to go to get a guardianship, at least of your estate, because the trust continues in existence and someone has access at all times during disability and death. Yep. So what goes in a trust? Anything. Houses, vacation homes, boats, airplanes, bank accounts, CDs, all of those types of things can go in the trust. What can't go in a trust? What we call qualified accounts, IRAs, 401ks, Roths. Those have to be owned by individuals. Why, you ask? Oh, the IRS. They want their money and they want their taxes, okay? So if we want to protect or get money of these kind into a trust, we have to liquidate. I have to say this is not a comprehensive list of all things. Disclaimer, but yes, life insurance can go in a trust. Yep, you can, and remember, whether it's revocable or irrevocable, the trust can own the asset during lifetime, okay? And the trust can point, or the asset can be pointed to the trust at death. Okay, so you may continue to be the owner of the life insurance, but make your trust the beneficiary. Okay, or if it's an irrevocable trust and we're trying to get asset protection because we have a whole term policy that has a cash value that we don't want to have to surrender, we make the owner of the policy the trust, irrevocable trust, to get that 5-year protection. Okay, briefly touch on this. This could be its own hour-long presentation. While I stated IRAs can't go in a trust, we can create IRA trusts, okay? And the advantage there is it allows us to kind of prevent the kids from taking your $1 million IRA and liquidating it all because, heck, who cares? I don't care if I pay the taxes, right? It gives us some added protection, really kind of control from the grave of that. And there's some other tax benefits in it too, okay?
It isn't also like children, like if they would get it and they're young, it holds it until they are old enough to make the decision.
Correct.
To spend that money.
That is 100% true. Because in Ohio, minors can't inherit, okay? Additionally, a lot of times, I mean, heck, I know that I don't know because he's not 18 yet, but I wouldn't be handing over a big chunk of money to any of my kids at 18. They like video games too much. And those darn Tesla Cybertrucks. So, but correct, it allows a minor to inherit. It allows us to get that tax spread, and it keeps it out of probate court. Revocable and irrevocable trusts, they are, the advantage over a will is that they are private documents, okay? We do not have to go through probate to disperse a trust after we die, okay? So private, much harder to contest, okay? Because the individual who wants to contest has to actually go to probate court, file the pleadings, pay the filing fee. They have to initiate it, okay? Also, trusts avoid creditor claims, okay? So, because we aren't going through probate. And if there's no probate, creditors can't make a claim. Yeah, so the question was about funding. Funding's how we fill the bucket. When can we do that? And then also, what's a pour-over will? So yes, when we do a trust plan, so when we do packages for clients, it's comprehensive. So we're doing a trust, whether it's revocable or irrevocable. We're doing financial power of attorney, healthcare power of attorney, living will, HIPAA, and your disposition of remains or your funeral representative. And then we also do a pour-over will, okay? And so what the pour-over will does is it acts like a backstop to the catcher, okay, in baseball. So if that backstop wasn't there and he didn't make the catch, who knows how far away it's going, right? So the pour-over will allows us to shorten that probate process, okay? It gives us, we still have to deposit the will, we still have to open probate, but once we do that, we just say, hey, Your Honor, she didn't mean for that car to not be in the trust. Can you give the trustee an order that allows us to pour that car into the trust so we can distribute pursuant to the terms of the trust, okay? So ideally, we never want to use that pour-over will, okay? But it's there just in case. Because we've done the work to create that trust and the thoughts about where we want things to go, that we want that trust to be the governing document of our stuff. Does that make sense? So how do we fund a trust? We fund a trust by changing ownership of the asset. So how do we change ownership of a house? The deed. So assuming you're married, you and your wife would then sign the deed over to the trust, and now the trust owns the house. That gets recorded, trust owns the house. Just like if you have a bank account at Right Pat, I change ownership of that account to the trust. I have an investment account with Charles Schwab. I change ownership of that to the trust. So my life insurance policy, I change ownership of that to the trust. So just because you create a trust and you have your bucket, it doesn't do anything unless you fill it. And you fill it by changing ownership during life or by putting the trust as your beneficiary where it then flows to the trust at death. And you can do that anytime. You can put assets in and out of a trust anytime. Okay?
What are the guidelines for a trust?
What are the guidelines for a trust?
When should you have one? There's a level of assets before you do a trust.
So good question. I get that every day. Guidelines. When should somebody have a trust? How many assets do you need to own to have a trust? Depends. It's up to you. I have people who the only thing in their trust is their house because that's their life savings. The equity in that house is their life savings. I have people who, have $20 million and have a trust, right? It's not about how much, right? It's about whether or not you want things to be easy on the people that come after you. And that's what a trust does. It makes it easier on them, right? Yeah. Yes, ma'am?
Do you need a will and a trust both?
Yes. So what I just talked about, that pour-over will, We want to have that because we want the trust to govern, okay? And it happens a lot. It happens a lot with vehicles because people get a new car and they forget to call us and they forget they need a TOD or, on the vehicle. It also happens, not so much anymore, but back in the day with the Christmas savings accounts, the Christmas funds, right, where people would put money away to use for Christmas, yep. Kids don't realize mom and dad had that, and now we're probating for $300, right? So we want that pour-over will with the trust so that we can shorten the probate process and get those assets into your bucket so that we can make sure they go where you wanted them to go. For the video, the comment was trusts provide protection from remarriage, especially if the surviving spouse has dementia or something like that. New spouse comes in, takes control if the stuff isn't in the trust. And yes, we see it all the time.
And they had a trust, but it wasn't.
Wasn't funded. And quite frankly, it's probably one of the most common, when I have a new client come in to see me, one of the first questions we ask, right? Do you have a trust? Yes. What kind? I don't know. Is it irrevocable? Probably. Okay, are you the trustee? Yes, it's not irrevocable. Okay, well, but the attorney said that it would protect me from Medicaid. Nope, sorry, it doesn't. And what's in your trust? I don't know. Okay, well, let's start doing some digging, right? Well, how would I know? Well, you would have had to go to the bank and, you would have had to, well, my attorney didn't do that for me? No, we can't, right? Without your authority at least, okay? So yes, funding is a hugely important thing.
This newspaper came out this past week, the
Yeah,
local, talking about the big scandal with the quick claim deeds.
Yeah, the deed that.
Does this protect you from that, or what, they have a system for it?
Yeah, so there's, you see it on the news about these deed thieves, right, going and so does a trust protect you? It makes it much more difficult because the trustee has to sign, right? Can we prevent all fraud? No, but just like anything else in the news, it really doesn't happen that often. I mean, if it happened to me, I'd, be preaching about it, but it doesn't happen that often. It's difficult. One second. One way you can prevent that, though, is by recording your power of attorney in the county where you reside, because then they would, if they're using a power of attorney, that has to be recorded. Yeah, so the comment was Montgomery County at least has a form you can fill out that requests that they monitor your deed, and if they see something happen, they automatically alert the prosecutor's office. So yeah, lots of safeguards out there that we can do. Irrevocable trust, revocable trusts avoid probate, both lifetime probate and death probate, okay? They do not give you asset protection. Irrevocable trusts also avoid lifetime and death probate, okay? However, some, not all, but some irrevocable trusts will give you asset protection from creditors in 4 years, at least creditors that you weren't aware of, creditors in 4 years, and the nursing home in 5, okay? So these irrevocable trusts do give us the ability to do some asset protection planning from a possible long-term care event. What are the downsides? Of course, in order to get that asset protection, we have to give something up. What we're giving up is control. And sometimes that gives people heartburn, and I get it, but an irrevocable trust isn't an all or nothing deal, okay? So when I say you lose control, it means you can't be the trustee, okay? You and your spouse cannot be the trustee. So, well, who's the trustee, Rachel? Whoever you want, okay? It can be a kid, it can be a sister, a brother, it can be your banker, but you can't be the trustee. So what that does is it takes it outside of your assets, okay, for Medicaid purposes. It's still your asset for the IRS, okay? So we still get our homestead exemption, we can still write off our mortgage interest, those types of things, okay? But we can't control it. So if we put our house into the irrevocable trust, okay, and we want to sell, what happens is our trustee does that for us, the money flows back into our trust, and then the trustee goes and buys our downsized condo, okay? But the big advantage here is you're starting that 5-year look back for Medicaid because it's a gift. It's a completed gift when we give the asset to that irrevocable trust. That starts your clock for Medicaid. once we've made it 5 years and a day, if we have a long-term care event, we have the option of potentially going immediately on Medicaid, or we can still access those assets to pay if we choose a place like St. Leonard's that maybe doesn't take Medicaid, right? We still have those options, but at least we have the option. Think of it kind of like backwards long-term care insurance, right? We don't have long-term care insurance, but if we make it 5 years, now we kind of do, okay? So the question is, if you have long-term care insurance, should that be in the trust? No, it doesn't go in the trust. I should say it depends. If you've got a hybrid policy where you've got a guaranteed life insurance payout if you don't use it, that's different. But if it's just straight long-term care insurance, that's not, that's like having auto insurance. It's not going in the trust, right? But it's a good thing to have. So that's a good question. Yep. The question was, what do we do when a financial institution doesn't honor our request or makes it difficult for us to change our beneficiaries? They have their own rules that are not statutory, that aren't federal, that aren't Ohio, okay? They just make up these policies and then they try to enforce it. So to your point, what I always tell my clients, if they're not getting cooperation from their bank, guess what? Take your money somewhere else. And obviously not ideal if you're dead and they didn't do the beneficiary correct, but guess what? They're sure your estate could try to sue them to get fees back for the probate, but they're going to say, well, we never got it, or whatever it was, and now you're in probate. Yeah, it's a very frustrating, but guess what would avoid that?
Trust.
A trust, yeah. So the question is, if spouse A has all the assets in their name and spouse B needs Medicaid, what will the state of Ohio say? So Medicaid, whole topic for another day. My favorite topic, but the short answer to that is Medicaid says what's hers is his and his is hers. So it doesn't matter. That is not a tool of getting somebody eligible for Medicaid. Unfortunately, so generally if you're married, healthy spouse can have the house, car, and about half of the assets, no more than $150,000. Also, if IRAs are in payout status, those are exempt as well, okay? But to that point, it's what I do every day. I help families do Medicaid planning. I help families get on Medicaid. Don't let anybody ever tell you you have too many assets to qualify for Medicaid. If you're a married couple and one of you needs Medicaid, I can save everything for you and get that sick spouse on Medicaid. If you're single, I can typically save about half of what you got and still get you on Medicaid. So yeah, the question is, does it need to be an irrevocable trust? We call that pre-planning. And so yes, if you're healthy and you want long-term care expense is a concern, we take everything you're comfortable with that we can, we put it into the irrevocable trust. Your 5-year clock starts. When you're 5 years and a day, you're insulated. And it's like Medicaid doesn't even know you ever owned it. But you have to have the 5 years to get that full protection. Yep. Yes, ma'am.
You said IRA's payout status? What is that?
Yeah, so an IRA is in payout status in two ways. So if you're 73 and a half or 72, depending on your birth date, 74 here soon, depending on your birth date, the federal government makes you take distributions. They're called required minimum distributions because guess what? They want their money. The other way to put it in payout status is if you haven't reached that age requiring that distribution, you can just, if you're over 59 and a half, you can put it into payout status without a penalty. So you just pick, I want $100 a month, and now it's an income stream to you instead of an investment, in Medicaid's eyes. What's the cost of setting up a trust? What's the typical lawyer response? It depends. And it's an investment. I'm a certified elder law attorney. My partner is certified with the Ohio State Bar Association as a probate and estate planner. It's all we do. And our specialties and our certification require us to stay up to date on the new laws and things like that. So, we also have the ability, not a lot of firms have the ability to do these higher level plans, the IRA trust, the irrevocable trust, those kinds of things. So, it's an investment, but we're pretty good at it. And we like our clients, so we want to keep that relationship.